Every lawyer in the country knows a secret code to read and understand court cases, and even write them. And I will teach it to you so you can understand them better too. This is Civics 101, Law School 101 edition. I'm Brian, I'm a lawyer, and I'm here to help you understand your law and government better. Please comment, repost, share this video because civics videos are not the most exciting thing in the world and do not get out there unless you help. People need to learn this stuff, and if you keep sharing them, I'll keep making them. Okay, so it's my first day of law school and they hand me 2 pieces of paper. The first one has a case on it. The second one is an instruction sheet for how to brief a case. And I have no idea how much time I am going to spend doing this for the next 3 years. Really, the next 10 years. How old am I now? Briefing a case is a critical skill in law school, but most people don't call it briefing. They call it IRACing, and I will show you why. Issue, rule, application, conclusion. Issue, rule, application, conclusion. Issue, rule, application, conclusion. IRAC. Now, one of my professors taught me something a little extra, which do not ever tell an attorney because they will think you're crazy. Like, I don't even say this out loud, but this can be helpful. I say, in my head, quietly, FIRAC. Facts, issues, rule, application, conclusion. Shh. Just between us. Now, as many of my videos do, this one is going to start with a story and some stick figures. Mike is asleep in his house. He left the TV on downstairs. John is a delivery driver who's nearby, and to whoever said my cars look like Jetson-mobiles, if I could make the noise, I would. So John is driving his route through Joliet, Illinois, when he sees the TV on in Mike's house, and he decides, I am going to steal that TV. So he climbs through the window of Mike's house, in an attempt to steal his TV. But Mike wakes up, calls 911, the police show up, and arrest John on site inside the house without ever stealing the TV. John is found guilty of burglary and sent to jail. But he appeals his case because he says, I didn't actually steal the TV. How can I be guilty of burglary? Well, let's IRAC this case, shall we? First, we write down our facts. Here are the facts I've written down. John is a delivery driver. John doesn't know Mike. John decided to steal the TV, then broke in. John was arrested without having stolen the TV. Now, the issue of our case is what the big question is that we need to answer. I find that the easiest way to frame this is under does when. Under does when. Our big question is, under Illinois law, does a person commit burglary when they do all the stuff that we've talked about, but don't actually steal anything? Now we get to our rule stage. Now, in a complicated case, rules might be case law, they might be all kinds of different things, regulations, all sorts of things. But in this case, because of the way that I set it up, we're only going to stick to one rule, and that rule is going to be the Illinois definition of burglary, which is right here, the kind of highlighted part. Now, I have a little trick I like to use when I try to turn these statutes into English. I use checkboxes. A person commits burglary when, without authority, he enters or remains within a building, and in this case there's like 20 different examples of things that it's not just building, but building works for us, so I'm not going to go any further. It's aircraft, motor vehicle, railroad car, building works. With intent to commit a felony or theft therein. So now we get to the third stage, the application stage. In the application stage, what we're going to do is take our facts and apply them to our rule. If our rule included a lot of case law, we might be able to look at the facts that happened in those other cases and see if our facts are the same or different. That's part of the application process. But in this case, we're sticking to a statute, so we're just going to look at our checkboxes and see what happens. So first, without authority, we know that John didn't know Mike, so there was no authority for him to enter. Did he enter or remain? Yes, he entered. Was it a building? Yes, it was a house. And really our big question, did he have intent to commit a theft inside? We know that he got out of his car intending to steal that TV. So yes. So he meets all of the requirements. Now here's the last question. to answer our issue. Is there a requirement here that you have actually stolen anything? And the answer is no. All you have to have is intent to steal something. Now our conclusion is basically going to be the answer to our question from the issue. Under Illinois law, does a person commit burglary when they don't steal anything? Yes. Burglary only requires intent to steal. We have just IRAC'd this case, or briefed this case. Now, real quick, I want to give you a couple of pointers and point out some things that I did right and wrong. First, I want to point out one of my facts was that John was a delivery driver. Nowhere from here down did we need to know that John was a delivery driver. That wasn't a necessary fact. I would not have included that in my list of facts when I was briefing or IRACing this. But that's one of the common mistakes you make, like in your first couple of months as a law student. You include stuff that you don't end up needing. But you know what did turn out to be important is that he entered the house, and I didn't include that in my facts. That should have been up there, and it wasn't. In order to check one of my boxes, I needed it up there. You want to make sure that your facts match the rest of your brief. All right, last thing, and here's where I'm going to go particularly advanced on you. We've had some conversations about what defines a fact and what doesn't. But with this example fresh in your mind, I want to give you one more example of the difference between the courtroom definition of fact and what I would say is a more common, normal, conversational definition of fact. Let's say that Mike, our thief, was put up on the stand and he swore that when he was driving by the house, he saw something crazy on TV through the window, and he only broke in to see what was happening. And since he never stole anything, they can't really prove that he intended to steal it, right? So how is the fact that he intended to steal it one of our facts? Well, it's up to the jury to decide what the facts were. And the jury is going to listen to Mike's testimony and see whether he's believable or not. And if it seems like he's lying, they're going to say, no, he intended to go steal that TV. That story is ridiculous. And once the jury decides that he's lying, that's the end. It becomes a fact in our case. And generally, all of this stuff can be appealed to a higher court. The facts, because they were decided by a jury, 12 people picked off the street, are not usually appealable. So the jury has a lot of power. I know I keep talking about this fact issue, but it's because it's kind of hard to explain, and it's much easier if you see it over and over again in different contexts. And it is a really important thing to understand. Okay, so that's IRAC. You can now print out a Supreme Court case. I recommend something shorter and try finding the issue, rule, application, and conclusion. A faster way to do it is to get 4 different colored highlighters and highlight in different colors. That's the way I usually do it. I always use red for the issue, green for the rule, orange for the application, blue for the conclusion. I just picked those. You can do whatever you want. But it's a much faster way of doing it than rewriting it on something. So go try it out, and I think you will find that you will understand cases a lot better. Welcome to the world of reading in our secret language. You now have the secret decoder ring. Go use it. Remember, this is your law too. Now please share this video so people see it, and come back and watch more. Thanks a lot.